All right, if you are ready to embark on the 34 Act, far less interesting than Edward Snowden, but what are we going to do? It's, life is not fair. All right, why is no one here? Shouldn't have given you recordings. All right, it's okay. It's sunny outside, the spring is coming. All right. Okay, so don't forget office hours today, 1:20-ish. I'm not sure exactly when I'll get out of the Blue Sky lunch, which you're more than welcome to come to, actually. Should advertise that. Patrick Bolton's going to be talking about investor ideology. This has a red light. Can you all hear me? All right, if it dies, then call our friends at AV again. All right. All right, so we were talking about the Elkind case. Oh, just to review, office hours, like I said, 1:20 to about 3, and then I've got to run to a committee meeting, but I'll be back around 4. And I'll stay a little later. If some of you want to come at 5, if that works, we can do that. But if I don't hear from you, I'm out of here around 5 or 5:30. All right. So we're talking about Elkind. So I'm not going to spend a lot more time on this. I think we beat the civil liability for insider trading now. We have beat this to a pulp. We really should understand it. I would point out that under section, well, you saw in the Elkind case the court embraces this disgorgement remedy. So some of you were objecting to the analysis yesterday by pointing out that, yes, in fact, while insider trading might help those folks who are the counterparties to, who are not the counterparties to the insiders, so those folks who bought or sold at the wrong price, it could be that insider trading, because it makes prices more accurate, helps them in a way. It nonetheless definitely hurts a particular group of folks who are the counterparties to the insiders trading. And it is that logic that maybe we shouldn't even try causally to think at all about the connection between insider trading and the other sort of inaccurate trades that happen following the insider's trading, because remember we said, if anything, the insider, by trading in the direction of the truth, actually moves the price in that direction. So you remember we did, what did Ben, how did Ben call it? Cliffs versus slopes. Yeah, so he sent me this great email we'll talk about in a minute. So the cliff or the slope, so the idea being that if we have more insider trading, right, then there's a bunch of transactions over here that are happening at more accurate prices, right, because they're happening further down the slope and not before the cliff. All right, so that's a problem for this causation story. So we see the courts looking for a better story of causation, and that is trying to scope the liability. And so it seems that the most sort of natural group to focus on are the counterparties to the trades made with the insider, right? So the insider's trading in here, and yes, it is beautiful outside, and everyone is slow to arrive, but welcome, welcome. So everyone says you have these folks trading against the insider here as the insider trades, and the idea is that the insider's profits are really, in a way, sort of directly equivalent to the losses suffered by the insiders, theoretically anyway, by the insiders' counterparties, right? So just, I'm not going to spend too much more time on this, but just think, you can go back and look at Martoma. Think about the folks Martoma is selling. There are folks who are buying from Martoma, and they're buying from Martoma at a price that might be a little bit less than the price they would have paid because Martoma is moving the price a little bit down. But they're definitely sort of the natural group of victims to think about in the sense that they bought at a price that was too high. Now, I keep pushing you to think like it's kind of weird to call them victims because they were probably going to buy anyway. If anything, they would have bought at a higher price. But in our sort of search for justice, right, in our desire to pin the blame of Martoma's conduct and say, look, he actually, like, someone was defrauded. Who was it? So we're probably going to want to pick that group. That's the intuition here in these cases. And in fact, it's very natural then to think of the disgorgement remedy, even though it's justified by references to, the concern of liability sprawling. The weather must have been really nice today. Everyone's sort of coming in. All right. I thought the recording would have this effect of, but no, they're all right. This is great. So if you think about insider trading as you're concerned that the liability will just be draconian, as the courts like to call it, then maybe the disgorgement remedy is attractive because it does seem in this kind of distributive justice sense to right the wrong. Right? So if you feel that there was a wrong and the wrong led to ill-gotten gains by the insider, then even though actually, if anything, those folks paid a lower price than they would have if they had traded absent the insider, if they were up here on the cliff, well, we kind of feel like that's the natural cap or limitation on damages. And it turns out that in the PSLRA, as you saw in the readings, there is, in fact, a Section 20 of the 20A of the 34 Act. See if I can get this up on the screen so we can all see it, which is limited to insider trading liability. That is, to violations of well, it's not exactly explicitly limited to 10b-5, but kind of talking about 10b-5. Any person who violates any provision of this title by purchasing or selling a security while in possession of material non-public information shall be liable in an action limitation on liability. Well, let's finish this. So shall be liable in an action to any person who contemporaneously with the purchase or sale of securities that is the subject of such violation has purchased or sold securities of the same class. So just applying this to Martoma's victims, so basically what we've got here is a rejection of, statutory rejection of the idea that folks who are sort of, suppose Martoma's trading kind of stopped, okay, like here. Like say he traded through here, and that's not exactly right, but imagine that's, we can think of it like that. So the one limitation here is that if you weren't trading at the time that Martoma was trading, you're out of luck. All right, so that's the straightforward limitation we talked about even last week, that if you're further down the chain and it just happens to be that, you want to try and claim that you were hurt by the insider, but we can't actually pin your trading to the time period in which the insider traded, then we're going to say, too bad, no recovery for you. But in addition, right, we're going to see subsection B here, that even if you did trade at the same time as the insider, your damages, the total amount of damages imposed under subsection A, shall not exceed the profit, gain, or loss avoided in the transaction that are the subject of the violation. And moreover, there's going to be an offsetting for liability. But the key thing I want you to see is that the disgorgement remedy is now actually statutorily the limitation on damages for insider trading liability. So that's the law, lest you wondered whether we would learn law. In fact, now you know what it is. Now, so a couple comments on our discussion yesterday I got via email. I'll just talk about them, and then we'll move on from insider trading completely. So one comment I thought was a good one. One of you asked me, well, aren't insiders actually trying to hide their trades, right? So how is it that insider trading benefits the folks on the cliff who would have been on the cliff? Because aren't insiders trying to trade in such a way? We saw this in Martoma. The guy used a bunch of dark pools and whatnot to hide the trading. And so if insiders are trying to hide the trading, how is it that we can tell any story that they're benefiting the rest of the investors who would be trading in the shares? And the answer is that while it's true that insiders try to hide their trades, it's also true that any informed trading that is directionally imbalanced moves the price in that direction. So even though Martoma could have been more aggressive and not hit his trades and potentially made more money, he nonetheless did in fact move the price a little bit. We saw it falling a little bit over those days. You're absolutely right to say that the social sort of benefit from insider trading declines as the insider is more, like camouflaging the trades. That's correct. But it's also true that competition among informed traders would have the effect of reducing Mr. Martoma's ability to camouflage his trades. So Maddie asked me this question yesterday, which was a really good one. And she said, well, how is it that competition has this benefit? How does competition work in this setting? And we touched on this last week, but I'm just going to remind you because this is important, okay? It's true that Mr. Martoma, who acts like a monopolist, for those who have some sort of, if you've taken antitrust, you understand that what monopolists can do is behave in markets in a way that benefit themselves because they're free of competition. They extract the surplus from the counterparties. So, this insight from this paper, this Kyle paper that I keep talking about, that's sort of unintelligible if you're not a mathematician. But the insight is that the insiders like Martoma will act like monopolists temporally in time. They will actually do exactly that. They will camouflage their trades and try to make this slope as non-steep, it's the opposite of steep, as possible. So if there are more than one, in particular, informed traders, their competition will make this line steeper. And why is that? Well, imagine if you're Martoma and you think, well, I'm going to try to hide my trades. How am I going to do that? Well, I'm going to trade kind of slowly. And if I trade slowly, then my trading won't be detected. But if I trade slowly, I'm also exposing myself to the risk that there's another informed guy out there who will trade a little bit faster. And if that person trades a little bit faster, they're going to move the price a little bit quicker, right? You're going to have a little bit steeper line. And then, therefore, I'm going to reason, if I'm Martoma, that maybe I shouldn't be so passive and I should be a little bit more aggressive. And so the benefit of price accuracy to the market increases, like prices become more accurate more quickly as more people engage, particularly in a competitive way, in this kind of informed trading. Does everyone understand that? Okay, are there any questions on this? I want to make sure this is clear. Now, I just want to reiterate, that is not a policy justification for legalizing insider trading. Because remember that market makers will systematically lose to insiders, and they will enlarge bid-ask spreads. You'll remember the 9 and 11 example that you should have down pat for the exam. You should be really comfortable with calculating the welfare loss. Welfare is the wrong word. Calculating the, let's just say, the difference in prices between buying the price you can buy and the price you can sell. That is driven by insider trading. And remember, we said that that wedge between the price you can buy and the price you can sell actually strictly increases, always increases, with the likelihood that you're facing an informed trader. And so market liquidity is impacted negatively when there are informed traders. Prices, though, are in fact more accurate, right? So it's this connection between price accuracy and liquidity, and the puzzle really is that the paradigm that we use for thinking about liability, tort liability, remember we're in a tort paradigm here, where Martoma sort of injures his victims, that paradigm is not well suited to market prices, right? There is a kind of incompatibility between what market prices do and the sort of harm to victims that Martoma's conduct seems to want to make us sort of remedy, right? Because the harm to a victim is not completely connected to the change in the price. And in a way, you can think of the entire, we're about to embark here on class actions, you can think of the entire class action field as struggling with, you know, how much should we compensate buyers and sellers when the determination of compensation is based on the market price. Because the market price, you'll remember from our first few weeks, reflects the expectation, the market maker's expectation of the value of the asset of the firm after observing a particular sequence of buy and sell orders, or after making certain assumptions about who is likely to have information and who isn't. So that the link between what market makers do in setting these prices and the potential injured parties, sort of who are the victims here, that link is not very clear. And so that if you think about it at the highest level, theoretically, sort of analytically, the highest level of generality, the problem is the lack of fit between the price mechanism and the notion of compensating victims for injury. All right, so that's the big theme. Ben, is Ben here? There he is. Hi, Ben. Ben sent me this great note about high-frequency trading, and he made the point that in Preet Bharara's world, basically you can think of the beneficiaries here of this moment of disclosure as being high-frequency traders. Because high-frequency traders, upon an announcement, they think of it like there's a bit of a mad rush. And if one way to think about what Bharara is doing, or what insider trading law is doing in this aggressive interpretation of insider trading law, is just reallocating the profits from informed trading from the Martomas of the world to the HFTs of the world. Does everyone see that? Nod your heads if that's crystal clear to you. Let's make sure all of us understand that. No? Okay, so let's just clarify why. So what happens when a company makes an announcement? And this is really relevant to fraud on the market. Just think about this. A company makes an announcement and they say, our earnings are disappointing. Our earnings are 10% less than what you thought they were going to be. What happens at that moment? Like at that nanosecond, right? How does the price actually, how does the cliff created? Like, how is there a cliff? Why doesn't it just stay at this elevated level, right? Well, there's some algorithm out there that hears the information, like reads it on a newswire or probably, I don't know, and goes, oh, that's not good. Let's sell, okay? A lot of these algorithms, they don't really know how good or bad the news is. They just know that, like, it's bad or good. They don't really know how bad or how good. They don't really know that this means that the company is worth 5% less than the current price or whatever. Is this $10 of bad news a share? Is this $20 of bad news? They don't know. But they do know that the news is bad and thus you should sell. And the algorithms will sell until, there's various ways that they put probability distributions. It doesn't really matter. At some point, the algorithms stop. and the price kind of reaches some level. You know, analysts might chime in and say this is what they think it's worth. And Ben makes the really insightful point that this process of selling in response to public news is actually like no different from what Martoma did, right? It's just happening in a very compressed, like economically it's no different. Clearly legally it's different, but economically it's just sort of like, I'm the high frequency trader. I get the news first because maybe I have a computer like next to the Dow Jones Newswire, or even better, I have like someone listening. I've like tapped the phones of this company. I don't know, like somehow I find the news out first. And so I am, for a brief period of time, I am Martoma. I am the legal version of Martoma. I will not go to prison, but I will make the same money he does. Kind of, right? It's not exactly the same amount because I have a lot shorter time and I'm going to face some competition, but at least as a group, we can definitely say that as a group, high-frequency traders make that profit in the short amount of time that they have to process the information. So Ben really hits the nail on the head when he says what our policy is doing here is actually playing favorites between investors, between traders. We've decided, they, Bahara, SEC, US Attorney, you name it, decided to benefit the fast over the informed. The fast listeners get the gold rather than the informed Martomas, okay? And the question, the policy question, is whether that's a good idea. The key assumption I think a lot of people make, and that's probably wrong, is that the price actually reaches the same level when the high-frequency traders trade on the information. One reason that might not happen is because imagine if you are, remember what Martoma was doing. He became an expert in the Alzheimer drugs. Dr. Gilman, these folks really put in a lot of time, cost to themselves, to figure out whether or not the clinical trial results were really, in fact, bad news for Elon. And if they were, how bad the news would be. And so actually, it could very well be that the high-frequency traders don't make that effort. And a thought experiment for you to think about, one that is a good example of like a multiple choice question, is suppose the high-frequency traders, think back to Martoma, to Elon, they bid the price down to, $25 rather than the 20 or the 11 that it ended up reaching. And it's going to cost, the legal version of Martoma, right, his good twin, it's going to cost the good twin Martoma something on the order of, I don't know, $20 a share effectively to figure out what the news means. Well, it could be because the high-frequency traders gobbled up the profit. Say that they got the price down to here, right? That the slope, like from here to here, okay, the profit that Martoma can make in this window, good twin Martoma, is too small for those costs. So not only could it be that we're favoring high-frequency traders, notice, this is a pure allocation, just like we've just played favorites. We favored one group of traders, and these folks make billions, right? This is a massive industry. So the implications here are non-trivial. We've decided to favor them over Martoma. Not only that, in fact, it might be that the Martomas lack sufficient compensation to engage in the marginal corrective effort to decode the information. Okay, yes, Sam.
I guess I'm wondering why we would assume that the high-frequency traders as a group would make the same profits as Martoma, because weren't you saying that in the Kyle paper there was the idea that if there was competition among insiders, there would actually be less profit and faster price movement?
The expected, right, so let's disentangle 2 points in Sam's question. The aggregate profit, so imagine 10 competing insiders, and the aggregate profit they could make is 100 million. So then you just divide 100 by 10 and say, on average, I don't know if I'm going to be first, but there's a 1 out of 10 chance I might be first, let's say very simply. So I can expect to make 10 million. That's just 100 divided by 10. Does everyone see the math? You know, if there's 100 million to be made. But it could be that if there's 100 informed traders, then my expected profit is only 1 million, right? And so in general, you know, fix the aggregate, divide it by like n, where n is the number of informed traders. The expected profit to any informed trader is going to sort of go to 0 as you have n going to infinity. Okay, don't freak out. So basically, if you have a lot of informed traders, just basically each one is going to make very little in expectation. They might be first and get the 100 million, but the chance of that happening is very small. So that's a point that, one point. Another aspect of this, and maybe more relevant to Sam's question, is what this number is here, this 100 million, this aggregate amount. And it turns out, I made this point to you earlier, that the more competition there is, the faster you have to trade, and thus it's not entirely correct, and this is a fair point, to say that the numerator here, the aggregate informed trading profit, is equal to what Martoma was able to make. And that's because of the non-linearity that market makers seeing intense, quick demand will quickly drop the price, thereby taking some of your profits away. So it's correct to say that one point in Bahara's defense is that the aggregate mispricing post-disclosure, so if we just look at this group, that mispricing may be smaller because the informed HFTs are going to compete so quickly that they just move the price very fast, and each one has something like less than this, right? Because in aggregate it's not 100, in aggregate it might be only 50. Okay, so that's correct. But remember, Sam, that if we're really going to do the social welfare calculation, as again crediting Ben for cliffs versus slopes, Ben makes this great point that like in the cliff, this is like a long period of time where everyone traded at the wrong price. So basically, you can't quite, if you're going to compare the Martoma to the HFT world, remember that in the HFT world you had a long period of time where everyone got the price wrong until the announcement. So you got to add that back in, right? So if we're comparing competitive informed trading in this window, and we can actually chop short the duration when the price is inaccurate, then there's a definite welfare gain. Like everyone is better off. Well, put welfare in quotes. It's not clear. This is all zero-sum trading, but let's just think about it as our victims here are mispricing, folks who trade at the wrong price. So if you shorten the duration, and think about this in the light of really the broader tension between informed trading and disclosure, right? So what disclosure is embracing the cliff and saying, well, let's just let the HFTs duke it out right after the announcement. But then, you know, you've got this long period of time where the price was wrong. Whereas if you have the informed traders, you know, you might not get perfect competition, or you won't get necessarily the same level of competition that you got with the HFTs. But if you can get some competition, you might be able to get the price accurate much earlier in time, thereby saving all of these transactions from occurring at the wrong price. Yes, Joe?
Just to make sure I understand the model, when you're talking about allocating profits to high-frequency traders, which might make the price not accurate, would it solve that problem, or am I misunderstanding the model if you suspended trading in the security at the point of disclosure, had like, you know, a 24-hour period or some period, and then allowed people to trade?
No, so this is like problem, like aspect 3 of the concept. Let's make sure everyone's on the same page. So we're going a little fast here. So, you know, so point 1 is that if you have a lot of competition, the aggregate gains to informed trading will be smaller than if you have a monopolist. That's point 1. Point 2 is that you have to take into account the fact that post-disclosure there were a lot of trades happening at the wrong price. Just review so everyone's on the same page. So that means that the sum total of losses is likely to be much higher in this scenario because even though the insiders make less, a lot of other people trade at the wrong price. And now Joe's asking about my point here, which is that even when you have high-frequency traders, it may be that the price doesn't reach the true value for another reason, which is that the remaining gap here that the HFTs, remember the HFTs are going to put the absolute minimal amount of effort they can to arbitrage the price. So it could be that this remaining gap here is in fact too small to compensate the post-disclosure martomas, right, who want to now pour through the clinical trial evidence, and they look and they say, oh yeah, it could be that in fact Elon's stock is still a little too high, and if I put in a lot of sell orders, I'll make some money, but that profit I'd make is just too small to make it worth my while. Right? That's really, it's going to take me 3 weeks to pour through these clinical trial results, and the most I could expect to make is $2 a share. You know, right? So there's a question that's actually could prolong, you know, the mispricing, right? That the mispricing might continue for even longer. It may never, you know, or maybe a very long time. And the real economic question is if you are, you know, a biotech company and whatnot, think about what that means. That actually it could be that the absence of profits for informed traders keeps your price sort of, you know, for a very long time at the wrong level, and thus you're not able to fund your operations. So that could have real economic impacts. All right, we haven't really gone down that more speculative road, but a lot of biotechs say that they can't get analysts to look past their earnings numbers. This was a common complaint over the last 5 to 10 years, and one possible explanation for that complaint is that analysts are kind of like the legal versions of Martoma. They need to have an expected profit to their investments in information acquisition. And when HFTs move the price too fast, you know, post-disclosure toward the accurate level, that leaves too little money to be made by those who would consume this information. Okay? Yes, Magdalena. Yeah. Right. Well, that's the question. So legally, the two groups are treated very differently, very differently. Economically, I'm pushing you to think about whether they are so different. One way they might be different is in this law of unintended consequences sense, that the public analysts might be working with a much smaller profit, expected profit. And so the public analysts might be willing to expend a lot less money on acquiring information. So, you know, what way does that cut? Yes, can you tell me your name again? Arthur. Hi, Arthur. Definitely an oversimplification. Yeah. Yes. Okay. Yeah. That's right. So you're right. So it's very good and fair to push back on my pro-insider trading indoctrination of you by pointing out that, that bid-ask spreads are really important. And like you said, the market makers here, who are actually our high-frequency traders today, are not thrilled that they might be facing a Martoma. They lose tremendous amounts of money taking the opposite sides of the deal against the Martomas of the world, and that they will need to be compensated for to stay in business, and so they'll widen bid-ask spreads, making trading more expensive for everyone. So that's right. That is unequivocally correct. We should make a little bit of a distinction between, when I say high-frequency traders, so there are sort of your market makers, right? So those who are really often taking no directional view on the firm. And then we've got the group that I'm more focusing on post-announcement. We've got these kind of algorithmic news processing group, and they are not actually providers of liquidity, but actually they're taking a position, and the two can sometimes overlap, but often we're talking about a little bit different subsets of the high-frequency trading world, and some might correctly point out that this group isn't really high-frequency trading. People might say that's sort of more algorithmic trading. I don't know. I never really liked the distinctions. But yes, market makers are anyway, they're just always pricing on zero expected profit. So they're just setting bid-ask spreads to adjust for the possibility of informed trading. The directional folks here are like your news traders. Yes?
I get the end part press conference. You also saying that
Yeah.
for victims,
Yeah.
there will be less of it. But I'm to say price accuracy is you might have equal profits, but by
Yeah. That's right. So always, the gains and losses to inform trading in these aggregates socially are always canceling out, equal to zero.
right. In that sense, the victims are
Well, it depends on how you. So you could have replied to Bahara when you saw the press conference where he calls out Martoma for making $200 million. You could have said, "Oh, Preet, yes, Martoma made $200 million, but in the aggregate, the social welfare loss was zero." Because Martoma gained $200 million and his victims lost $200 million, and so how are their victims? So I think we have to decide what we mean by a victim. So are we going to pick one half of the trade and say the one half who lost is, trading is always a zero-sum game. So we're not talking in securities markets about like setting property on fire and actually destroying resources in the economy. So the whole idea of victims here is completely arbitrary. We're just going to pick a group. And you're right. So yeah, you could say that about Martoma. You could say that about everyone who traded at the wrong price. There was a counterparty who traded at a good price, who lost by trading at a wrong price. There's always a counterparty who gained by trading at the wrong price. So yeah, so I'm just kind of picking the ones who lost, calling them victims. And if we accept that, which you might completely reject, but if you reject that, then you should reject the theory that Martoma's counterparties are victims, because they're no different, right? They're just the unlucky ones, and he's the lucky one. It's a society we have unlucky and lucky ones. So if you embrace that view, it takes you to the view that there's no victim anytime in securities markets. These are just zero-sum bets. I'm not going to go that far. I'm going to allow us to feel the pain of those who trade and lose because they trade in the wrong direction. That hurts. It's real pain. But if we're going to feel that pain, let's think about how we minimize that pain, right? And so this is really just about variance reduction. For those who are more technical, this is all just about whether we care about reducing variance. Okay, Davia. Yeah. High frequency? I'm trying to think which young man. Okay, so no, I'm not saying anything about fairness. I don't know. Does someone have a theory of fairness as to which group? I mean, look, I'm not trying to be flippant. Most theories of fairness do start from sort of distributive justice. So what you might not like is that Martoma's a wealthy guy, but so are the HFTs. And so if you're going to, and this is Ben's point, why this is a really insightful point, is because they're not so different. So if you just don't like the fact that the rich get to walk off with profits from informed trading, then why are you so okay with the HFTs or the news traders, let's say, more the fast news traders? Why are they somehow, like, are they poor? They're not poor. So whatever your theory of fairness is, maybe it's, distributive justice, great. You should have a problem with that too. Yes, Joe. Because they're publicly traded, like Virtu's publicly traded and these guys? Okay. Less seemly. All right. So let's deal with the first one. Well, what the heck? Why not? It's the second to last week, and we have a little time. So since you want to go down the fairness trail, okay. So let's ask the question: would you then support, Joe, a rule that you get to have these profits if and only if you're a publicly traded HFT? Because if you're not publicly traded, then you're definitely not, your wealth is not accessible to the general public. Like, a lot of these, quantitative hedge funds that are trading on news, like, you can't just buy it. Like, I can't, you can't. Some of them are publicly traded, yeah. But would that be the rule then? That we should have?
I think that the idea is if the information is public, then high-frequency trading is available to everyone. So even though not all high-frequency traders are open for everyone to buy into, there's at least one high-frequency trader that the means of making their money from trading is distributed.
Does anyone disagree? You all convinced of the fairness of high-frequency trading? No, that's not the popular opinion, but maybe it is in this class. Okay. Nobody wants to disagree? Andrew?
Well, I don't think the average high-frequency trader is any less or more accessible to the public than the hedge fund that Martoma worked at in the first place, right? Insider traders are still employed by funds that people can invest in that are just as accessible or inaccessible as the HFTs. It's really just a question of how that trading's done and not who's doing it.
Bingo! What do you think? Convinced? I think you can buy into Martoma's, you can buy the SAC.
But if all of the Martomas, if Martoma was always trading on behalf of hedge funds, you could buy into it.
He was. He didn't have that cash, that capital himself.
Right, but it's still, almost, like, there might be some guy, whereas you can't research, like, which guy is so crooked that he can like, that would not be a good, in my mind, that would not be a good way to hedge funds. Whereas if you said, who engages in high frequency?
Nice. Okay. Okay, this is great. So I have this idea for a paper, which is like, what is reputation? Actually, it's a part of a, Darius Palia and Jack Coffey and I are working on this. And the idea is, okay, what is reputation in the hedge fund industry? Like, which funds have a good reputation? Probably the ones who make the most money. So, is it so hard to find the funds if you have a fund that's posting, 20% a year or whatever the, and like Steve Cohen's, like he himself would brag about the Edge. I sent you the link to Black Edge. Like, the fund was known for being a firm that traded on edgy information. Is that random? I mean, they would grow, and they would grow. And actually, our point in this project is to think about, like, what that means. So the bad actors are actually the good actors when they deliver higher returns. This is not on the exam, but just think about it, right? Okay, so is it random? Other thoughts? Why should we prefer? I mean, I don't know if it's random. I'm trying to find a rationale. The means are accessible. All you got to do is co-opt Dr. Gilman. You don't have to break into, like, a plant or something. You just got to go hang out in Ann Arbor with Dr. Gilman. Like, it's not that hard. It's probably a lot cheaper. All right, what other theories? Okay, costs, right? Real resources. A lot fewer real resources were expended by Martoma. A couple plane tickets to Detroit, coffee with Gilman, versus whatever the HFTs are spending in the millions to co-locate their cables next to the SEC and like Secaucus and these places, so that they can get the announcements first. And in the tremendous computational processing that goes into beating each other, Martoma expended far fewer resources. One more for you, and then I'll let you push back. Let's talk about how the money's used. So Martoma is going, and what is he doing with his $100 million? Well, he's probably spending it in Florida. Think about, in the broader economy, all of the folks whose livelihood in Florida turns on, directly or indirectly, on Martoma spending his money, right? You've got a lot of, lower income folks whose livelihood turns on that. And I'm not sure, as a class, the HFT investors are spending their money. One reason to be doubtful of that is that as you distribute capital among more wealthier people, there's just fewer. They're less likely to consume it. So maybe Martoma is consuming more cash. Okay, these are just some reasons. This is devil's advocate here, but Okay, Kate. Well, we don't. I'm just guessing. Well, he was in Florida and he had bought a house, and that's true. So probably, yeah. So let's rehabilitate Joe. So if it's there's a wealth dynasty story that's probably, at least to me, very compelling, right? Which is Kate's point, that maybe I don't know, it's all accessible, it's all open, but the HFTs are under more of a pressure to distribute their money, whereas the insiders might be building up family dynasties. That would be an interesting study. Like, what do insiders do with their cash? Well, once they're caught, they have to disgorge it. But if they don't get caught, you wouldn't know who they were, so you wouldn't know. My guess is that it might, in fact, just build up in these kind of family dynasties. It's maybe never used in consumption and perpetuates the stagnation of wealth, right? So we've got, which hurts income mobility and all kinds of things, right? Because now their kids can go to the elite law schools like Columbia, take your spot or your kid's spot, and so, yeah. Okay, Andrew?
To push back on that, family offices are becoming big investors. A lot of venture capital stuff there, so a lot more money flowing into maybe good ideas that otherwise wouldn't get it because money is being concentrated in families and then has to be invested somewhere.
There we go. Yeah, this fairness stuff is hard, Martin.
This might be really dumb, which should be just a preface for all my questions, but isn't there an analogy to the idiosyncratic versus systemic risk, in that this is kind of an idiosyncratic versus systemic benefit? With a high-frequency trader, you can apply that process, and you can know that process is applied. You don't need to know what specific stock is going to be involved or what specific information is going to leak. Whereas insiders is kind of a one-off. And if you're going to prioritize one over the other, you might say that we're going to prioritize mailing everybody a check for $3 versus mailing everyone a lottery ticket.
Okay. I mean, I'm willing to bet that all of Dr. Gilman's contemporaries were amenable, at least in theory to the techniques that Martoma used. I mean, all 80-year-old doctors kind of like to hang around with, you know what I mean? Like, so I don't know, how idiosyncratic was it, right? Like, he just had to go buddy them. Okay, I'll take one more. Yes, Paul.
I think like another interesting distributed question
Yeah.
is how losses are allocated amongst distributors.
Okay.
You have the Bliss versus the Staples. I think the issue is just constant trading back and forth. They probably don't care that much about the Staples numbers. They keep the individual traders.
Yes.
But there's just a cliff in price. You have a subset of traders that frequently trade. So you have an unequal distribution that's the high frequency trading.
So in the limit, okay, I see your point. Yeah, that's nice. So in the limit, suppose the news is traded on the public news is traded on immediately, and there's like a massive sell order. Someone's going to eat that. Yeah. Yeah. But they're risk neutral. So they're pricing their losses on an expected value basis. So while that loss is large, there's only a 1 in something chance that it's going to happen, because, in fact, by definition, those two are kind of moving together, right? So as you increase the magnitude of the loss that falls on one trader, you also reduce the probability that any single trader will be the unlucky one. And so I'm not sure. You have to think of. Do you disagree?
I agree with that. But
Yeah.
I think there's like systemic limitations there. You have a few losses that can lead to
So you'd have So there's a potential systemic risk. So you'd have to think about whether that's macro correlated. So in a recession, like liquidity is tight, we're constrained, and so the one HFT who loses might in fact go under as a result. That'd be a pretty extreme, but I could see that working. It would be interesting if they care. I'm not sure these amounts are enough, but it could be. I mean, around the financial crisis, it seemed to matter, right? If you were the one who bought the company that, turns out had a bunch of toxic assets that are actually worth like nothing, and this is the end of, its existence, then in fact you might be really risk averse. Good example of thinking about systematic risk in macro economy. Okay, let's move on to basic. That was fun, but some of you want to learn the law. A few of you. All right. So basic v. Levinson. What happened in basic? April. All right. Preliminary merger negotiations. I'll tell you. September 1976. There's these preliminary merger negotiations between Combustion and Basic. Basic denies 3 times that it's engaged in merger negotiations from 1977 to 1978. And on December 19th, 1978, Basic accepts the merger offer. Now, Basic introduces a new kind of problem. I say new, I've talked about it before. But now we have shut the door completely on insider trading liability. We will no longer now think about the wealthies, Cayman Islands. Now we are done with Martoma, and we are asking about companies like Basic who tell the public something, or don't tell the public something, that perpetuates mispricing. All right? And this is really the big wide world of securities class actions, because, and this is really the analytical problem, unlike the Martomas, you really don't have any insider who's just kind of hanging out ready to trade the price. These are companies who are pretty well behaved, and so, if you are, well, let's work with the buy side. We've got a lot of sell side stuff. So let's think about Basic. So the stock price is down here, and then there's a merger announcement, and it jumps. Okay, and basically can you hear me? No, this is dead. All right. Basically, the group that is suing here are the folks who bought in this period claiming that they bought, I'm sorry, the folks who sold in that period claiming that they sold at a price that was too low. Let's see if this one works. Hello? So, in this setting, the problem is you don't really have an informed trader. So the question is going to be really simpler in a way, because we just have a moment of disclosure, and we're only trying to figure out as a kind of compensatory matter, right, whether there should be compensation for the trading at the inaccurate price, and if so, who should be compensated? So it is similar to the insider trading setting in that we always have this insurance problem that you kind of worry about just the answer being anyone who sold here, because then not only are they getting insurance, but it's coming from these shareholders. And so it's actually a transfer from future to past shareholders. We talked about that. So what happens in BASIC, right? Well, BASIC is, in fact, in part, an application of our materiality standard, our beloved materiality standard applied to preliminary merger negotiations. And as you know, the court says that there is not a bright line rule of materiality. It's really just restating the TSC industry, the Texas Gulf test, and then later sort of finds its way through TSC Industries. But at the end of the day, it's really not that interesting in the materiality setting, other than standing for this proposition that we have to do our traditional materiality test. We'll talk a little bit about procedure tomorrow. I think we offer a securities litigation clinic or class, I'm not sure, but there's a lot of procedural stuff around class actions that we'll touch on, but it's kind of its own thing. And what I want to make sure you walk away with knowing in the next 4 classes, knowing the key, 5 classes, the key components of that. And so one starting point is the fact that materiality we're not going to talk too much about, because materiality is something that is proven after the class certification stage. We'll go through, we'll just sort of recap Rule 23 tomorrow and talk about what are class actions. Why am I talking about class actions? Remember that from Civ Pro, that if you want to bring a claim here and you're not able to establish that you were personally defrauded by the company, which you weren't, right? As a shareholder buying on the open market, you didn't walk up to a company executive and say, sell me a share of stock, that company executive sort of remaining silent or telling you some falsehood. So you have to, base your claim on your open market purchase or sale, which means effectively for it to be also worth any money that you're going to have to bring a class action, right? This should be self-evident because what you're actually claiming is that all of the shareholders who bought or sold in this window were buying or selling on the wrong price, based on the wrong price. And so we will cover procedurally a little bit of what's going on under Rule 23 tomorrow. For now, just realize that this setting, it's not just because it's a class action, but this setting in which there is, in fact, no bad behavior by any trader in the marketplace. There's just potentially bad behavior by the firm or insufficient disclosure. This setting makes it very hard to apply the reliance doctrine as we have learned it so far. All right? And that's the key starting point for understanding fraud on the market. Remember, going back to affiliated OOT, where you had, I just mentioned briefly, you had this face-to-face transaction that then later on the courts are struggling with, how much of this behavior should we compensate for? And the conclusion is, well, only the trading that's directly happening with the insider. And that's the rationale behind the disgorgement remedy in the insider trading setting. Here, there's no insider, right? So remember, this problem arose in our discussion of reliance and causation, that there's a sense that the other folks who were trading after Martoma's stopped his trading, or even the folks who traded with Martoma, there's a sense in which there's a lack of causation as to anything other than Martoma's own fraudulent trading, right? But then you can say all the more so when you talk about the setting where there is no insider. Because all the more so here, you have effectively no bad trading. All you have is the disclosure or lack thereof of information that is misleading, and misleading disclosure or the lack of disclosure of truthful information so as to leave a misleading impression on the market. And so if you were to apply, like, sort of mechanically this causation idea, you would come to the conclusion that everyone who bought or sold at the wrong price, sort of bought and sold kind of because they were not told correctly what the company was worth. That's the kind of problem that we see. And in BASIC, in fact, the court introduces a doctrine, this fraud on the market doctrine, that says more or less just that, right? So a few caveats, and we'll look at those. But what the court points out is that it's actually, so this is on page 243 of the opinion. We agree that reliance is an element of a Rule 10b-5 cause of action. Reliance provides the requisite causal connection between a defendant's misrepresentation and a plaintiff's injury. There is, however, more than one way to demonstrate the causal connection. Indeed, we previously have dispensed with a requirement of positive proof of reliance where a duty to disclose material information has been breached, concluding that the necessary nexus between the plaintiff's injury and the defendant's wrongful conduct has been established. And here the court cites affiliated OOT, which actually involved a face-to-face transaction, but is being now used to serve for this broader idea, to supply a precedent for this broader idea that, in fact, we can go further than face-to-face transactions. And a little bit further down, the modern securities markets, literally involving millions of shares changing hands daily, differ from face-to-face transactions contemplated by early fraud cases, and our understanding of Rule 10b-5's reliance requirement must encompass these differences. And then there's this nice, set of citations about the theory here, which is pretty simple. The idea is, well, I'll just read, I don't know, it's kind of eloquent. In face-to-face transactions, the inquiry into an investor's reliance upon information is into the subjective pricing of that information by the investor. With the presence of a market, the market is interposed between seller and buyer and ideally transmits information to the investor in the processed form of a market price. Thus, the market is performing a substantial part of the valuation process performed by the investor in the face-to-face transaction. The market is acting as the unpaid agent of the investor, informing him that given all the information available to it, the value of the stock is worth the market price. In an open and developed market, the dissemination of material misrepresentations or withholding of material information typically affects the price of the stock. Purchasers generally rely on the price of the stock. Okay, so basically, no pun intended, BASIC says, look, if you are buying or selling in this window, you are not just buying and selling because you've decided to buy or sell for some other reason, but we're going to presume, this is a presumption, we're going to presume that you looked at the current market price. So if this is $20, that you looked at $20 and you said, oh, it's now trading at $20. That is why I am going to buy or sell. In the case of BASIC, that is why you sold. So there's this story that's being told that market participants use the price in formulating their investment decisions. And there's some important language in here that we get sort of discussed more in detail in Halliburton 2, which you read, I hope. That let's see. So on page 247 of the opinion, 246, the end of 246, the presumption, the fraud on the market presumption, is also supported by common sense and probability. Recent empirical studies have tended to confirm Congress's premise that the market price of shares traded on well-developed markets reflects all publicly available information and hence any material misrepresentations. It has been noted that it is hard to imagine there is ever a buyer or seller who does not rely on market integrity, who would knowingly roll the dice in a crooked crap game. Indeed, nearly every court that has considered the proposition, Okay, an investor who buys or sells stock at the price set by the market does so in reliance on the integrity of that price. The Basic Court allows, at the end of 248, any showing that severs the link between the alleged misrepresentation and the price received or paid, or his decision to trade, will be sufficient to rebut the presumption. And it gives this example that if petitioners could show that market makers were privy to the truth about the merger discussions, and thus the market price would not have been affected, the causal connection would be broken. The basis for finding that the fraud had been transmitted through the market price would be gone. All right. Does everyone understand fraud on the market from those passages of Basic? Bottom line is that in a claim like this, in a securities fraud class action claim, the reliance, the transaction causation element that we discussed yesterday is presumed to be satisfied. Okay? It's presumed to be satisfied because plaintiffs are entitled to rely, think of this as what the court is saying, on the market price. The assumption is that the market price incorporates all information. And so the reasonable plaintiff should not be trading on the basis of any information that they possess other than the information that's already in the market price. So there's a little bit of circularity here that you should start to feel. And it's actually a circularity that's been around efficient markets theory for a long time, which is that if markets are in fact perfectly efficient, then you should never trade, right? Because if in fact Basic is worth $20, like literally that's the exact accurate price and will be for all time, then you should never trade. But the court doesn't really flesh this out, just kind of says, well, you might have a different view about what's going to happen. You might disagree about the prospects of the firm, but at least the information should be in the price, and thus your decision to trade was probably, we are going to assume, motivated by that information. But we're going to allow that presumption to be rebutted if you can bring evidence that, in fact, certain kinds of information did not make their way into the market price. All right, is this clear? This is just the fraud on the market presumption. Yes, Abir.
Does this only apply to class action lawsuits? Does the reliance causation presumption only apply to class action lawsuits?
So let's think of a setting. So not in insider trading. Definitely not. Because here the claim is based on the insider's fraudulent trading. And we know the rules. I would say it would be pretty much impossible to bring a non-class action claim for securities fraud of this kind. I'd have to think. So formally, just to be clear, formally, Basic is not articulating its fraud on the market rule as limited to class actions. Right? It's not. Formally, the answer is no. But I'm hard-pressed to think of a case where you would maybe... So the problem is going to be, right, that if the kinds of cases where you wouldn't bring a class action might involve like private companies or sort of thinly traded firms, and then you could arguably rebut the presumption, right? So because you could say that if I'm not trading in an efficient market, then the presumption shouldn't hold, and those would be maybe the only kinds of cases where maybe you had like an actual negotiation with the firm and you could claim a reliance claim. So you'd be closer to like affiliated OOT, in which case, it wouldn't be available to you anyway. So does that make sense? So it really arises, and it only can arise, if you will. I'm trying to think of a case where it could otherwise arise, where you have large trading volume in the company's securities, and for that reason, your own damages might be small, but you're bringing a claim on behalf of everyone who traded. Other questions? Is this clear? So what happens in Halliburton is basically, this Halliburton 2, this is a 2014 decision by the court. The basic presumption is reaffirmed. And we're given a nice articulation of the reliance presumption on page 1127 of the casebook. So this is like good stuff to have for the exam. 1, the alleged misrepresentations were publicly known. 2, they were material. 3, the stock traded in an efficient market. That's where most of these sort of, typical publicly traded firms are going to fall off. And 4, that the plaintiff traded the stock between the time when the misrepresentations were made and when the truth was revealed. So you've got to be in some window. So let's just be clear. If, in fact, BASIC had not said anything about whether if there was a no comment, okay, that would not give rise to a 10b-5 action. Remember, there's no general duty of disclosure. And while we've waxed on theoretically about investor expectations, don't misunderstand the black letter law. You cannot just bring a suit against a company for not saying anything. You cannot claim that you expected, the world to be different. That's just the theory. At the end of the day, you are going to have to point to some misrepresentation or omission that is actionable, that is in violation of a duty to speak, potentially like the duty to correct. Or, there are affirmative duties that arise. We know that under the 34 Act. We discussed, for example, Form 8K, which requires current reports in a set of circumstances. But there is no general duty to disclose material information. You should know that one for sure. All right. So Halliburton says, look, when these elements are satisfied, in fact, we can presume that there was reliance on the stock price. There's a nice discussion, I'll spend the last few minutes on this, on page 1130 of the casebook. Halliburton 2 led to a lot of academic debate. Because when BASIC was written, when BASIC was decided, we were living in a very different world from the standpoint of economic theory. The efficient markets hypothesis, which underlied BASIC, really sort of had its heyday in the 70s. So it was very natural for folks reading BASIC to say, yeah, of course, it makes sense that we can rely on a market price and thereby attribute trading decisions to sort of learning from prices. Today, the evidence is really strongly weighs against the idea that markets are even anything close to fully efficient. The court in Halliburton acknowledges that evidence, and on page 1130 rejects the sort of inference that that evidence should overturn the presumption, right, as a matter of law. So the court says, this is Roberts, even the foremost critics of the efficient capital markets hypothesis acknowledge that public information generally affects stock prices. Debates about the precise degree to which stock prices accurately reflect public information are thus largely beside the point. Halliburton has not identified the kind of fundamental shift in economic theory that could justify overruling a precedent on the ground that it misunderstood or has since been overtaken by economic realities. So the court actually rejected, there was this amicus brief. A lot of economists, particularly behavioral economists, have argued that, prices deviate from fundamental value for all kinds of reasons. Halliburton was making the case that we'll talk about more tomorrow, that the bar to bringing a class action claim is relatively very low. And, Jack Coffey talks a lot about this, that, we have an entire cottage industry of plaintiffs' firms who wait for a company to make an announcement that then turns out, like taking an earnings announcement, that turns out to be wrong in some way, or to even just make a vague statement about their business plans. They pounce on it, they bring a suit, and it turns out that because of this presumption, because of the fraud on the market presumption, you can bring this massive class action claim. There's no requirement to show that the investors relied on the misrepresentation in making their trading decision. So, this is a pretty powerful presumption, and it kind of fuels this industry of securities class actions. Because, there could be 99% of the time, you could have good information about the company, and then there's this, 1% that's wrong. Well, remember, materiality is going to be post-class certification, so the time you get to materiality, it might even settle, or in any event, by that point, things aren't looking good for the company. So if you think about it, there could be some small bit of false information out there, and Basic, and thus Halliburton, allows us now to infer that every investor who bought or sold during that window was actually relying on that information in making their trading decision. So this is, the fraud on the market presumption is a very aggressive view of causation, right? Because unlike the approach we took in the disgorgement of insider trading profits, here we're basically saying, open the floodgates. Anyone who traded in this time is entitled to rely on the market price, actually did rely. We're going to presume that they actually did rely on the market price. Well, next week, we'll focus on loss causation and try to understand in Dura, when we get to Dura, how the court is nonetheless trying to cabin and limit how much liability will accrue. But it is, in fact, a very, very broad rule. So, okay, so tomorrow, what we'll do is talk more procedurally. So reread, I think there's a discussion of Amgen in the readings. Reread that. Reread the material. There's the intro material on Rule 23. We'll do a little bit of procedure, just so you understand the mechanics of how these class actions work. I'm going to send out a little bit more reading. We may not get to the international stuff, but there's a nice article by Alan Farrell up at Harvard, sort of thinking about the implications of Halliburton for securities fraud. He's consults on these things all the time. And there's a discussion. We're going to talk about event studies, the role that event studies play. And he has a nice 15-page article coming out in the Washington University Law Review on kind of what are the puzzles raised by Halliburton. So I think that would be nice to read, at least over the weekend. We'll talk a little bit more about how the court is trying to limit the scope of securities fraud liability. Let's just say that a lot of it really stems from the fraud on the market presumption, as I said before, which expanded the scope of liability way beyond what we had in the insider trading setting. Okay, 1:20-ish or so. I'll see you then for office hours or tomorrow morning. Hey, Michael, what's up?
I wanted to go back to the discussion we had about the insider trade. We really focus all the time in the discussion on all those people who trade on the market, but we forget about the inside information, which is the asset of the companies, right? So by depending, well, if we incentivize insider trading, as I think sometimes you might be inclined to propose, would be at the detriment of companies' assets, which are fundamental assets.
Would it? Why?
I referred to your article about the cyber hacking and trading by hedge funds on the information they got.
Right.
Maybe you were still on the side of like they are doing something probably wrong.
I am pushing you to think about this.
No, I know, but
My view is that the costs of liquidity are a non-trivial reason to prohibit insider trading. Probably the most compelling reason to prohibit insider trading is liquidity, but it is far from clear to restrict insider trading, to say you can't trade on inside information, because of the point made about the bid-ask spread, that markets become less liquid. that aggregates up and affects a lot of people. That being said, I'm pushing, your intuitions, you come into the class thinking insider trading is bad. I'm trying to get you to see that it's actually a complicated story, and it depends on who's doing it when. In the cyber hacking, I'm not at all suggesting in that project that, that it should be illegal. We suggest a cap on recovery to some extent, but we allow the hackers to recover some of their profits. Part because we think that that promotes efficient information production and also real economic benefits of finding out about these vulnerabilities. So, my view is a little bit ambiguous. I think there are times when informed trading is justified. I think that what I want you to see is that the approach that the U.S. Attorney's Office is taking, the SEC is taking, actually has unintended consequences, right? They're actually choosing winners and losers. And that's a policy choice like any other, right? So it's not correct to say that Pripahara is against informed trading, right? He's just in favor, as Ben really nicely pointed out, he's in favor of HFTs getting the money. Right. So that's a policy choice too, right? And I'm just saying we should be engaging with these policy choices. In the end, we might think that's justified, but we should justify that decision, right, rather than pretending that it's not a decision. Does that make sense? Because it is a decision. And I want you to be seeing both sides of it. And it's not at all that this is like, we should now legalize insider trading. It's that insider trading does, there are harsh penalties. Martoma's spending 9 years in prison. So we should think about whether that's socially desirable, right? Like that, it should be something that we really debate.
In this whole trading regulation in the United States, it's so vague, and usually when you
It's all judicial,
when you
yeah.
have a penal law, you should know what you can do, what you can't do.
As we saw, one read of Martoma is that Dirks is dead. Like, one read of Martoma is to completely get rid of Dirks, and that is why Martoma might be, feeling like it was a little unfair. Yes, absolutely. Davia, what's up? Hi. Yes.
Okay, so to better explain the question I was trying to ask you in class, so Martoma is this dude over here. He's up here, right?
Well, he's kind of going down the
Well,
line.
he's going down the line.
He's just on the
here.
winning side of all. He's sell.
And
Right.
this side is like our high yield
Yeah.
investors.
High frequency traders,
I'm
right?
sorry, actually, why is it on the
Yeah.
high frequency trader
Yep.
people.
Yep.
So the guy with the cap on his head, the young man, was basically saying that we're making a policy choices for who to penalize, right?
Ben?
I don't know his name.
Well, Ben made this point to me via email.
Okay,
Yeah.
the via email guy.
Yeah.
Yes. So that's the basic point. Like,
Yeah.
why are we penalizing him versus these guys?
Well,
Or, like,
we're playing favorites.
we're playing favorites. And then I accidentally said fairness, and then
Right.
he
Well,
jumped
no, but that was a fun.
point,
But yeah.
But I was actually, I'm sorry.
Does that make sense? So we're just choosing to give the money to these guys instead of.
Instead of him. Okay.
Might be a little less money, maybe a lot less.
Yeah, because then what's this whole thing? This dude hit me right here with the.
Well, so the point here is that high frequency traders might bid the price down to a level, but it may not be the same level that it reaches with Martoma.
Okay.
It might kind of not make it all the way.
All the way. And so the question that I was trying to ask you yesterday that I was also confused by is that, like, we just like, okay, so yes, like Martoma was selling here, but like, was he necessarily while the price is up here?
Yeah.
Like, couldn't didn't you? Isn't my understanding your officer as you're saying that maybe something else that besides like something else could have driven the basically the price down to where he was kind of selling it at,
Yeah.
right?
Yeah.
And then,
Could have.
So then,
But-
like, you kind of would have gotten lost in this, right?
Well, could have, but we don't know that. I mean, nobody else was informed, as far as we know.
Yeah, but the reason why why I asked that is because like then it would be like you couldn't necessarily like charge him for anything. Because how would you know, right?
Right, but they establish criminal liability for insider trading not by price movement, but by actual, he placed the trades with his broker, and he knew the information. So it's you got to establish those elements. Yeah. Does that make sense? Yeah. Yes. I've got 2 minutes.
Okay.
What's up?
It's just a quick question about what you mentioned about the
Yes.
introduction.
Yes.
You said that it's really it's all about fairness and
Yeah.
what do you mean that what they want from insider trading is to reduce variability? It seems like the cliff introduces more volatility in the market than